Good evening, everyone, and welcome to Vidhi's discussion on Rukmini's book, Rukmini S's book, Whole Numbers and Half Truths. This is the book that we have, and we have Rukmini with us. And this discussion is specifically going to focus on legal data and data from courts. And because this is, to be very honest, a very nascent field, I cannot imagine having this discussion about a decade ago, because I don't think there was anyone doing the research, or if they were too scattered, or nobody else was aware of it. I'm glad that we're having this discussion in 2021, where we can be joined in person here. We have Leah Varghese of Daksh, we have Sushant Sinha of Indian Kanun. Don't worry, they'll be on screen soon. We also have Apurv Anand of Civic Data Labs. We have Ms. Bharti Ali from Haq Center for Child Rights. We also have Devyani Srivastava of CHRI, all of whom have in some ways been part of this conversation in trying to understand laws and legal data and so on. So this is an important conversation because this has genuinely changed the way we understand how our courts, how our police, how our legal institutions work. They have offered new perspectives on what needs to change and what is really the problem, which I don't think we all fully understood till very recently. And this has moved the conversation vastly forward. But I'll still say this right at the start, and I will say this right at the end. We are still in day one of the conversation, but this is a good opportunity for all of us to get a sense as to what data has brought to the conversation. So I'll start off, of course, by introducing the book itself. Rukmini, as you would all know, has been a data journalist, and she's also a freelance writer. And this is her first book. A lot of this, some of you may have read. I think some of this has been covered in our previous writings. And we specifically are going to focus on the first chapter of this book, which deals with the police and courts. Before I begin, I should also mention that the publishers are offering a 40% discount for those of you who wish to purchase this book. My colleague will be sharing an email address. If you wish to purchase a copy of Whole Numbers and Half Truths, please do send an email to the email address which has been put in the comments, and with your address. I will once again repeat the email address and the details that you need to send for a copy of the book. But let me start off the discussion by giving a little bit of personal context on why this area interests me so much. I was a practicing lawyer in Delhi between 2009 and 2014. And I did have one case in the Delhi High Court, which was a criminal case, which was about 5 minutes. Actually, it took 5 minutes at the end of the day to dispose of the case. But because I had to wait for the case to reach, I spent 4 successive hearings in 4 different weeks, waiting for this case to reach. On each day, I saw something that I hadn't expected to see, and I didn't know how to make sense of it. The judge would call for case so-and-so. There would be on one side a large family, on the other side would be the accused. And generally a woman would come wearing a burqa, and the lawyers would introduce the case. The judge would ask the woman in the burqa, okay, what do you say? And she would say, yeah, I went with the man. And then suddenly the whole family would explode. There would be tears, there would be anguish, people would be screaming, and then the judge would calm down. And then it occurred to me, this was a bail hearing. This is a bail hearing where the accused is the man saying, I've been accused of sexual assault and kidnapping by the relatives of the woman who has come consentingly and willingly with me. And it wasn't even such an exceptional case because you could see the boredom with which the judge was handling this. It was like, oh, not another one of these. I mean, he did the right thing, obviously. But I thought, wow, this must be such a big deal. Surely I'll hear about this in the newspaper tomorrow. No trace of it. It happened once on each of the 4 subsequent days I was in court. Not the same case, 4 completely different cases. And then I realized this is something completely different that's going on. That's like what we see about sexual assault and kidnapping and crime statistics has no bearing to what I just saw unfold in court. And then I happened to read Rukmini's piece in the Hindu, I think it was, first from the, in the Hindu about Delhi, and then from Bombay, which finally showed the truth. And that is what is explored in the first chapter, the first part of the first chapter. So maybe we can begin, Rukmini, by sort of laying out for our audience and for us What put you on the path of saying, I want to read every single judgment on sexual assault delivered by Delhi courts in one particular year?
It was a path of insanity.
Okay.
I wouldn't recommend it to anyone
Right.
seeking to keep their sanity. And as I'll say a little further, I would hope that we're now reaching a place where you don't have to read every single one.
Sure.
I think we're getting there. So I just want to start by thanking you so much for this, Alok, and for everyone here and joining here as well. I completely agree with Alok when he says that this couldn't have happened 10 years ago. It couldn't have happened 7 years ago when I wrote the Hindu article as well and was reading all of this with one tab open for 6 months, and I never closed that tab and just kept chipping away at it. Okay. And then the text search would collapse and then I'd have to start from the beginning. It's a dark chapter. Okay. But just to explain a little bit more about my thinking around data journalism and as it applies to this judicial data in particular. I started as a regular beat reporter, as all lawyers start with being sent to every corner of the country to deal with of the city they're in to deal with small cases. That's what a reporter is sent on as well. And what I got to see was really the way data operates in real life, the way a spreadsheet actually works on the ground. So, if I there's a night shift reporter concept, which is when you're a very young reporter, your job starts in the evening and finishes through the night. And so often you spend hours in a police station kind of hoping that a crime takes place so that you have something to report on the next day. Yeah. So you see the way, the sort of, to give it a fancy term, the socio-political environment in which an FIR is created. You see that actually playing out on the ground. You also see this in courts. Sometimes I was assigned trials to cover, but very often these were small trials that I was interested in. And, they were such neglected trials that the outcome sometimes depended on whether I was there or not. If I was there at the back of the court, the judge would hear it or the judge would dismiss it, which places an enormous pressure on you to show up every time. But it included things like, a woman who was about to be convicted of homicide after 14 years of incarceration, during which time her husband had passed away. They were both co-accused of the homicide of the murder of their own children, in which there was absolutely no evidence, and they were then acquitted. The judge actually told me that if I acquit her, this woman has developed a mental disorder while incarcerated. Her husband is no more. Where will she go tomorrow? Please find some women's shelter. And what is the word? Putting the date ahead.
Adjourning,
adjourning until another date. Find a women's shelter by then and come back. So really got to see the law not as we imagine it being practiced, but as it is actually practiced. What you all see in the course of your work. And what drew me to the two particular pieces of the IPC that I've looked at in this, one is to do with sexual assault and the other was to do with causing hurt using a poisonous substance, as esoteric as that sounds, is seeing the sort of disconnect between what is going on the ground and what the data was showing. In the case of the sexual assault statistics, again, what drove me to it ended up being a combination of sort of personal intuition, reporting experience, and then what the data showed. After the 2012 Delhi sexual assault, I was living in Delhi at the time, and a long overdue necessary conversation around safety, women's rights, sexual violence began. But what also ended up happening was that the media lost the plot, which is the way they began covering all FIRs that had 376 in it, became frankly unhinged. And I could see in the reporting, and this is something I'm happy to explore in other parts of looking at judicial data as well, the concept of scripts, which we know are deployed in FIRs all the time. And I began to see this because news reports are faithful reproductions of FIRs with absolutely, very rarely is there extra reporting added to it. And I was seeing these things time and again. I was seeing cold drink bottles with a
Moving
intoxicant in it, and I was saying moving cars.
Yes.
And I actually began to feel, do I need to worry when I'm in a market that someone's going to, bring a cold drink bottle and it's going to have some intoxicant in it? Do I need to worry when I'm standing on the road to take an auto that this moving car is going to pass and pick me up? And in no way do I want to minimize the fact that sexual assault, violence, molestation, all of that goes on in large numbers which are not reflected in the data. I don't want to minimize that, but I do want to sort of call out both the police statistics and the media's role in it. So I think all of us here have broken our heads over judicial data, but I just want to say that imagine the state of police data, that it was so bad that I turned to judicial data. So that's how bad it was. When I knew that we are forming all of these, and not just our thoughts and beliefs, we're forming laws based on what the NCRB seems to be showing. We're doing things like, raising the age of consent for women. We're doing things like, raising the bar, removing discretion in sentencing, all of that. We are doing based on things that we are forming out of the NCRB and out of media reporting. Then I felt like I need to turn to the next best thing, which is courts. And I do want to say a couple of sort of caveats to it, which is I don't want to give the veneer of certainty or of even scientific sort of perfectness to what I did. I would say that the report that I did would probably not get accepted in a peer-reviewed law journal. Sure. It isn't, some of these conclusions which were drawn by piecing together conversations with judges and public prosecutors. It's not hard science. So I do want to say that it's not that this work sort of, replaces or does what scientific research on the judicial system would do. But it did end up showing me what you were seeing in court, which is that these were scripts being repeatedly deployed, that women were consistently deposing, that they wanted to go with the man. In so many cases, they were already pregnant, married, all of that had happened. And, I began to see this thread of interreligious and intercaste couples often being the ones targeted, which is something I think we should all be very worried about given the current environment against interreligious marriage in particular. In the case of the causing hurt using a poisonous substance, that's actually, it ended up being a byproduct of looking at sexual assault in Bombay. So I was looking for 376 and I was having to do it manually. And I kept coming up against, I can't remember what the section was. 328. Why is there this epidemic of 328? What are these poisonous substances that are just, running rife through Bombay? And then again, you see exactly the same script deployed again and again. And what was happening is that the drug mephedrone was at the time not yet in the NDPS, what is it called?
NDPS Act. The schedule.
Exactly. It wasn't in the NDPS schedule, so and the cops were seeing it on the street, so they did what they thought, what they argue was the next best thing, which was to use this section. It was clearly the wrong section because it needs to, you need intent to cause hurt, and that isn't what was happening in smuggling, in trafficking. And what you do end up seeing is a sort of suspiciously high number of Muslim accused and 100% acquittal rate. So there's also sort of, I want to bring in points around conviction rates and acquittal rates, which matter a lot to judges. It's on their minds so much.
All the time.
And then we do need to think about the role that media reporting plays in sort of going after judges for high or low acquittal or conviction rates. So
by the way, just to conclude the thought, on conviction and acquittal rates, it's not just the media. It is also the judges who assess other judges. So you have the High Court assessing the trial court judges and the district judges assessing the magistrate judges. And we know that this is a criteria that they use. And this is something that has caused problems for them. But let me sort of bring in 2 points, actually 3 very interesting points that you made. And I want to bring in some of our other participants also on this. The first was on making laws based on a certain kind of perception that ends up having the dramatically opposite effect. And I think one such example is the POCSO, which is the Prevention of Child Sexual Offences Act, which effectively ended up criminalizing teenage relationships. And we have here Bharti Ali of the Haq Center for the Rights of the Child. they have carried out research on POXO cases between 2012 and 2020. So Bharti, if you don't mind unmuting yourself and telling us what was the data that you saw and how did it sort of, confirm or deny some of the fears that people have expressed about juvenile offenders, and what did it really do to the implementation of the POXO Act?
Okay, let me just put it outright that if you want to have data on juvenile offenders, you really won't get much from the courts. You'll just get figures in the NCRB crime in India publication, that's it. But, when you're sort of looking at data from e-courts portal, sometimes you do get a sense of how many cases are being transferred and the reasons for transfer. So you get a sense that many of them are involving children in the 16 to 18 year age group who are in romantic relationships and have been booked. And now that JJ Act allows some kind of preliminary assessment, after which the case can be transferred from a juvenile justice board to the POXO court or the children's court, depending on the crime, for them to be tried as adults. So you do get some of that data from the e-courts portal. But our research in Delhi, Mumbai, which was looking at the period of 2012 to 2015, and then the recent one, which is looking at the period between 2012 to April 2020, actually gives us some very shocking data on the fact that about 25 to 30% cases are cases of romantic relationships. The recent data is about 19,783 cases, where we found that 39% of the cases are registered under a provision of the POXO Act, as well as Section 363 of the IPC for kidnapping and abduction, and a 366, which is kidnapping and abduction to compel a woman to marry. So very clearly, these are definitely cases falling in that category of relationships, whether consensual or not is the second line thing to look at. But these are also cases where our research shows that trials get delayed. It also shows there is a high rate of acquittal. We've also been talking to judges, and they say about 80% of the cases are 70 to 80% cases are cases of romantic relationships. The acquittals are again because victims are turning hostile. At the same time, our court experience with POXO cases, because we provide psychosocial and legal support to a lot of children. Currently, we have about 417 children whose cases we're looking at. But that experience tells us that there are also cases where girls are under so much pressure from the families to protect the family honor that even when they don't want to see the man or the boy behind bars, they are just forced to testify to that effect. There's fear of honor killing which is coming in some ways. So that's the courts are completely overburdened with these cases, and I'm sure we can do away with this. Raising of the age of consent has not helped. Mandatory reporting has not helped, because mandatory reporting is directly to the police. Unlike in other countries where there's a social welfare agency involved in between, we don't have that process lined out. And it's compulsory for everyone to report. So that's another problem. And you have minimum mandatory sentences taking the discretion completely away from judges. So we've seen judgments, in a POXO court in Delhi, there is a judgment where the judge says, okay, does this really get defined as sexual assault? Let's look at the definition of assault in the IPC. So definition of assault in IPC means that there should be use of force. Now, this is a case where there is no use of force, therefore no offense made out. So judges are trying different ways to deal with this situation that we are in.
But they get panned in the media for doing that. That judge will get
yes,
headlines the next week.
Absolutely.
Yeah, that's a great point. Thank you so much for that, Bharti, because I've seen a couple of other high court judgments also realize that they've been placed with a law that actually asks them to do something which to them feels unjust, and they have tried to find ways around it. And this is a great example of what happens when we react to a reporting without like actually understanding what the data is telling us and what the stories actually, rather than just going by the headlines. A second point that you mentioned, and one which I sort of want my colleague Apurva, who's here, who has done some work on this, to talk a little bit about, um, is the NDPS Act. And you mentioned the issue of the methadone. Now it is, of course, not so much of an issue. But here's the thing, our research showed the behavior of the police on this front hasn't changed. The almost pro forma, the FIRs that your research showed, that your book talks about, we found replicated in another state, which is in Punjab. And I'll just, if people can bear with me, I'll just move our facilities around so that Apurva can speak. Thank you. Just move the camera around.
So, am I audible?
Yeah.
Okay. So, Vidhi conducted 2 studies on the NDPS Act, one in the state of Punjab and one in Maharashtra. And what these studies show is the effects of handling a public health problem through a law. So, the NDPS Act had 2 objectives: rehabilitation of the addicts and deterrence for traffickers. But what we found in Punjab was, because there are so many strict liability offenses in cases of the NDPS Act, it puts zero responsibility for the police to actually investigate the case. So for 11,000 cases, we could fit them under 10 narratives. There were 10 templates that the police was following in these 11,000 cases. So that was the scripting of these FIRs. Another thing we found was that even though the conviction rates in NDPS cases are very high, and that is looked at as a success of the law, if you actually analyze these cases, like for Mumbai, we found that 96% of the cases under NDPS Act between 2013 and 14 were consumption cases. So you're not, and in these cases, 90% of the people were convicted. So you are not, so if they're convicted, they're either sentenced to the period they've already spent in prison, but they're never directed to a rehabilitation center, etc. So you're not fulfilling the purpose of rehabilitation. You're not targeting traffickers, because there are 4% of the cases that are actually dealing with trafficking. So I think that is something we found through our research, like something that seemed like a good idea, that seemed that the law was working. We found that even in Punjab, where these convictions were happening in cases of commercial quantities, because the law and the notifications subsequently were drafted in such a way, they were actually not targeting drug trafficking, and they were actually targeting consumers. And
That's the, thank you, Apurva. And we can just,
yeah,
sure, let's,
So on the NDPS research that I saw, I was really struck by the same day.
yeah.
I had never heard of this, and I really thought that this is a metric that needs to be.
Yeah, so over 90% of the cases in Mumbai, where there were consumption cases, they were disposed of on the same day. So these are cases that come before magistrates court, because they are for small quantities. They don't go before the special the court for under the NDPS Act. And yeah, 90% of them are being disposed on the same day, where 99% of the accused are pleading guilty. Yeah, that is what is really striking. And 90% of them are actually convicted. So these are really glaring statistics which show you how poorly the law is working. We can say as much as we want to about the high conviction rates, but if you're convicting people on the same day, 90% of them, that shows there's something terribly wrong with the system.
thanks, Apurva. We will just move the. Thank you. Which brings me to the third point. And I'd like, because this is something which occurs as a thread through the first chapter, through the 2 or 3 distinct parts that you talk about. A thread that sort of comes through is that the police in our country don't seem to be working in the way that, forget about popular media, even the regular media's reportage of it works, right? Because I think the one thing which you sort of pointed out, which is how they record statistics. more than how they record, what your work also shows is how they don't record, right? And that chart which you sort of have in your book, I won't spoil it for anyone. Please actually see the chart. It's a fascinating, it's a chart which sort of compares states where people have responded to surveys saying there is a lot of crime versus the actual rate of, um, FIRs recorded. And the chart is quite startling. It's quite startling because that chart should append our whole notion of a crime rate in India. So maybe if you could just talk a little bit about what is it that we're really seeing in these numbers?
No, as you say, it does. It is a thread running through about the police, but I would say it also brings me to a larger point, which bothers me greatly and ranges from all the way from police to health, which is that we sort of conflate large numbers. We equate large numbers with a lot of something happening.
Yeah.
While increasingly, my sense is that large numbers equal to a state or an environment in which greater reporting is possible. We've seen this in the case of COVID, and we see this for police statistics. And essentially, what I feel that in the media, what we end up doing is penalizing states that report better.
Right.
So if the popular narrative is that crimes against women are highest in Delhi, that is a reflection of a better reporting environment. And as I say, as the chart is supposed to make the point as well, is the states that aren't reporting large numbers to the police are the ones we should probably be the most worried about, especially because we do have household survey to triangulate with it, which shows something about the experience of crime. So I'd say this is a sort of running theme through Indian statistics, which is as long as we live in a country in which state capacity is so patchy, as along with development indicators and civil rights, the ability to report, as long as we do that, interstate comparisons end up really penalizing states that do a better job reporting. And even this is not a full answer. So if you see a large number of crimes reported in one state, you can't say, well, that state just does a better job reporting either.
Right.
So this sort of triangulation of experiences versus sort of output indicators is something we need to do, whether it is for health or for crime.
Right. And before I just move on to the next speaker, I'd just like to say hello to Samriddhi, who's from CDL, who's just joined us. We'll be calling on you a little bit. But at this point, I also just picking on the theme that Rukmini just sort of mentioned. If I could ask Devyani to just unmute herself and talk a little bit about the police reforms work that CHRI has been doing, especially because I think too much of police reform in this country gets focused on only one of two areas. One is who gets to be on top, which is who is DGP, how long they are, which is boring. But the other more dangerous thing is, of course, police violence, which happens quite a bit. But there is a big chunk in the middle, which I feel, which is like the day-to-day experience of people of policing, which is what Rukmini's work speaks to. So maybe Devyani, if you could talk a little bit about that.
Sure. Before I respond to Alok's point, I think the point that Rukmini was discussing and that has been brought out in the book chapter quite clearly, just emphasizing what crime statistics don't tell us, right? And the fact that it's police as the gatekeeper of the justice system get to decide what they will include and what they will not include. I think that is the thing that comes across when we listen to POCSO cases, when we listen to NDPS cases, and any actually atrocity cases. I mean, it's the same pattern. And I think that needs to be probed a bit more. And there are ways in which we can look at data that can tell us the scale of non-registration. So underreporting, you've recognized, and it's talked about. I think there needs to be greater recognition of the scale of non-registration that continues to happen, even when complaints are reported to the police station. And I think civil society groups will have so many examples of that. Just on sexual violence, we documented 17 cases of just rape and gang rape from UP, where the survivors had to fight for so many days to get the FIR registered. In one case, it took over 200 days for the FIR to get registered. So I think when we look at the problem of non-registration, there are 2 or 3 ways in which we can look at data on this. One is, of course, the crime victimization surveys that you also talk about in your book. And, we've done that. There have been efforts in India sporadically at state level. We did that in Delhi and Bombay as well. And incidentally, Government of India did commission an all India crime victimization survey in 2018, but unfortunately, because of the pandemic, that has been shelved for the moment. So crime victimization survey obviously will give us some sense of the actual levels of crime experience. But the other two ways I think that we want to emphasize is, one, how many FIRs are getting registered because of court direction, right? So when a complainant or a victim will not get an FIR registered in Thana, the next option would be either to write to the senior police officers and then obviously to approach the court. I think those cases would perhaps be a bit more accurate of crime taking place, just simply because of the process that it takes. So that's one data that I think studies have tried to bring out. And again, it's not obviously part of official data. The other is the developments in law itself. Now, again, this is a dilemma, right? I mean, on one hand, you're seeing the pattern of how law is misused when police register every complaint that comes. I think in sexual offenses, that's a sort of a implicit sort of thing that comes out when we read your chapter or your writing, and obviously when you review the cases that have come out. And so you want to sort of pause and say, should the police actually register every complaint alleging any sort of offenses? But that we have reached that stage in law because of the experiences of non-registration. So I think from an advocacy point of view, it's very crucial that that remains as the standard, as the requirement, because then the investigation should be able to bear out whatever there are, if there are false cases, etc. And so now we've reached a stage where laws are penalizing non-registration. So POCSO does that, Atrocities Act does that. And now 166 AC of the Indian Penal Code does that for non-registration of sexual offenses. There is no data being recorded on these provisions. So I think that will also give us a sense of crime that is experienced, but that is not entering the system. So these are 2 or 3 ways. And then, of course, looking at applications made to commissions, etc., other ways in which one can get a better sense of the crime that is experienced. So that's one point on non-registration. Very quickly on the acquittal thing, I think it's obviously an ongoing debate amongst researchers, scholars on the value of conviction rate and acquittal rate, and of course it varies offenses wise because the variables and the dynamics are different. But here I just want to emphasize that the Supreme Court actually, if the legal researchers will recall, that there's a judgment that requires police departments to actually review every case that leads to an acquittal, precisely because, as the judge in your chapter says, that every acquittal means a failure of investigation. And so, so when we talk about police reform, actually, there's also recognition of these initiatives to improve investigation and set up a team of officers that should review every acquittal. We've tried to look at whether states have put in place any mechanism like that. It's very difficult to obviously to sort of get data on something like this, but that's an ongoing point of research. And finally, on reforms. I'd say it's best not to get into it because it's such a long thing. Again, there are efforts that have focused on police station level, both to make it more citizen friendly, on procedural stuff to make it more accountable. So I wouldn't say that reform has not talked about these issues. I think there are sporadic efforts. It doesn't tell us a whole story, but there are initiatives that have focused on registration, and including rewarding officers who are registering more and more crime, including districts that are then recognized for a higher registration and report, precisely because it reflects higher reporting at current stage of sort of society and development. Eventually you want the crime rate to fall. But I think there are initiatives, there are systemic initiatives, there are procedural initiatives, there's training emphasis that is happening. And nothing that one can boast about, but there are efforts. So let me just stop there right now.
Thanks a lot, Devi. And I think that was kind of important to sort of point out that in as much as here we have uncovered a problem in the way we understand, look at and talk about data, there is never going to be one easy quick fix. And because that risks creating new problems. And as Devyani sort of pointed out, probably it needs a multiple set of approaches to sort of talk about the way in which, to sort of change the way in which police function in India, and where we can take the conversation on police reform forward. So in as much as that covers one big chunk of the chapter that you've written, there's another part which interests me because, again, as I said, my background as a practicing lawyer and also to take with other lawyers, what interests us is in terms of how our courts actually function, because we see it function in a certain way, and every lawyer will talk very confidently about how the courts actually function. But I think what the data is sort of showing us now is that this is something which is a huge problem. And because you have mentioned this in the previous section, that one big area and chunk of your research came from gathering the judgments of the court, of sort of having to go through them. And you mentioned that hopefully now that is no longer needed, which, by the way, we still had to do for our NDPS work. 11,000 cases. I mean, we found slightly more automated ways of doing it. But my colleague Neha, who would have spoken about that, unfortunately she's unwell today, but you quote her in the book. I just sort of wanted, and it would be great for all of us who have grappled in some, and I'll bring in the others as the discussion goes forward. What has been your experience, and what has specifically been your journey with approaching the judiciary for data, for trying to understand what's happening in courts, to sort of be able to get underneath the headline, so to speak, on what's happening with our courts?
Yeah, no, that's a great question. And again, something that's gone through a few different journeys. So there are a couple of indicators that courts, or let's say judges that I have interacted with, have decided are the variables to do with the judiciary, and that's it. They're unshakable. So there's conviction rate, acquittal rate, and there's pendency. My God, there is pendency.
Yes.
So
Yes.
you'll get a lot on that. But even on other things, there's still a lot of convincing that needs to happen. I suppose if judges see, or everybody sees, the overall environment to data-driven assessments of the judiciary change, then this can change. At the moment, if you attempt something like I once did about looking at the record of a judge, which is such a common practice in US data journalism, for example, and you fill all the caveats possible that, acquittal rates don't mean that the judge wanted to acquit, it's this, it's that. But they get super prickly about it. They are not used to those sort of data-driven assessments of their records. I feel like it's very important to do this about sentencing and bail. We really need to look at individual judge records about sentencing and bail. Of course, broader issues as well, but we should be able to say this about in bail. When I did this, and again, I feel that this was in a slightly, infancy of data environment, which was 2014. One of the, judges were happy to talk to me about this because this bothered them. Of course, many of them were coming at it in very misogynist ways. It bothered them because they are convinced that all women are lying and they just want to go with their boy. That absolutely is the case as well. They are not all coming at it from this attitude. But they found the data part of it very mystifying. So what will you do? How are you going to assess? Is there a commission? So, they weren't then used to independent sort of assessments of this. I think we've got a couple of good examples, more than a couple of good examples of the judicial process engaging in, or someone engaging with judicial data. Nick Robinson, who is a friend as well, but I think one of the reasons that his Supreme Court paper was so interesting is because it did approach it in a quantitative way, but told us so many qualitative stories as well.
That's
so
true.
I feel like it's a great model to try and do for maybe some high courts as well. Otherwise, I feel a lot of energy, in the Law Commission, for example, has been invested in pendency when it comes to data. I think there were some attempts again, with the Supreme Court registry, but I don't think those have gone very far. Even to the point that I would love to be able to tell a story about any high court in the country, just giving people a rough sense of what happens daily in a high court? How many people come in with what sort of case, at what stage is it, what sort of sections are it? I have no sense of it because I can't really get it from the data. And we somehow we can't get this sort of simple, broad thing from high courts yet. So I would like to throw this open to people who I do know have worked on this. But again, I just like to say that I know that in the last few years, there have been very important tech-driven initiatives, especially using machine learning to allow people like me or the NDPS team to not have to do so much manual work. And I know that this will break down at some, there are limits to it. There are a lot of quantitative stories that we need to be telling, which we should be engaging with people doing this sort of work, including people who are providing this as a private service, but we need to think about how to engage with them on that, and then think about qualitative work on smaller things. So I think whether it is the development data lab data set or Daksh's work, Agami's work, we need to I think we need to think better of the questions that we want to ask of this data. Those might be sort of qualitative questions, and then think about how to get at it quantitatively. Even in the data that does exist right now, I don't feel satisfied with what we've been able to ask of it. So maybe we need to think better about the questions that we ask of this data.
Right. And I suppose, and since you mentioned that private initiatives, tech-driven initiatives, we have with us Sushant, who probably started
The
tech-driven initiative. I'll just bring Sushant into the conversation, but specifically what Indian Qanun has done, and I know it's used as a research tool for a lot of students and for lawyers also, and increasingly we are seeing the courts as well. But Sushant, I'd love to sort of, and not a lot of people know about this journey, because I think your work and Daksha's work also inspired our research, and we said, hey, this is a way to actually study our course instead of talking about laws and stuff like that. So it would be great. And I'll start with Sushant and then I'll come to you, Leah. Like, what sort of prompted this? One, why you set up Indian Qanun? And two, how do you sort of see Indian Qanun as contributing to this conversation about, how do we understand our courts better? How do they function? So,
I mean, I started it when I was somehow got interested in law through blogs mostly.
okay.
And I was like, why I'm not able to understand anything here? And then I have to read Supreme Court judgment and finding, you go through these layers of citations and things like that and you get lost.
Yes.
So that time my feeling, I was like surprised why I can't find out what is the main judgment which says what is actually the law on the subject. Why do I have to move to 5 different things and still can't figure out what is the law? So that is why I thought building some kind of relevance for law search is important. Right? And that is when I tried the citation method, which was kind of popular that time, and kind of worked in the beginning. And secondly, to what everyone is now doing is, Indian Qanun is still a word search right now. There isn't anything more exposed to it right now. I've been trying to build more things, but hopefully should be released soon. But what Rukmini and others are doing is actually pretty intense job, because you have to go through everything to actually figure out what needs to be done and what are the different categorizing the cases, categorizing what happened actually in the cases. So, I hope to simplify that process at some point of time, but that is quite intense work actually.
Okay. And what sort of interests me is that, and we have discussed this between ourselves at one point, is that this has opened up, I think, courts and how they function to a lot more of the general public. I'm not saying that every person is now fully aware of what goes on. But I just sort of like, in your experience, and you've even won the award for this, but it'll be great if you could sort of talk about instances of how people have kind of been able to use a tool like Indian Qanun in terms of not just say for professional reasons, but how do you see people using something like this, which has opened up the way courts are viewed by the public, at least one part of it?
So I think the immediate beneficiary, I think, is actually the legal community, because they are actually able to use the tool far better than anyone else can.
Right.
But of course, that was not the idea. The idea was to actually expose it to more layman. And but I understand the law is actually complicated, and to get to the layman isn't that easy. And yeah, I'm sorry, what was the question?
So my point was, what sort of instances have you seen laypersons using the Indian canon?
Yes, so laypersons, I think this is for layperson, this is more like a WebMD thing.
Okay.
You read something and then you go and ask your lawyer, why isn't this being done?
Okay.
For example, when one of my friend was actually involved in a case, and he said, I read on Indian Qanun that I don't have to make a personal appearance for these cases.
Yeah.
But my lawyer says that it is not possible. That you have to come personally every time for the court hearing.
Yeah.
And I'm like, just check with your lawyer or change your lawyer. So that can mean it is more of a like you go put your symptoms in WebMD and say, oh, maybe I have a tumor. So and then you go to the doctor and doctor laughs at you probably. But that I think that it is raising at least some kind of questions to the lawyers on what they're doing.
And I think that is the kind of important function, because in a sense it's still early days. It is still in some ways kind of demystifying the court and demystifying the functions of the court, and people can actually read the judgments for themselves now. I think we take it for granted as lawyers that judgments anybody can read, but then we realize that no, you need a subscription to a journal, or even if it is an online subscription, you need this, or you need to know how to navigate some of the world's worst websites, which are our court websites. I'm sure people here have all tried using it at some point or the other. But I think the fact that if you do a simple Google search, like I use Indian Qanun because when I want a quick read of, say, the Puttaswamy judgment or some major, it's an easy and accessible way. And I'm sure people sort of want to talk about right to privacy, or you can do a quick survey of that. But thanks, Sushant, and I think that's one aspect of like this journey of using tech for. I'll now switch over to Daksh and Namrata. I think you will connect. Let's talk about specifically Daksh's journey on this. And Daksh was one of the pioneers of trying to use metadata to understand what is happening in courts. And we good to get a sense of what Daksh has learned from this experience, what this journey has been like, and what do you sort of see in this case in the future?
Okay, so to begin with, I think the judiciary as a branch of the government does put out a lot of data. I mean, compared to the legislature or the executive, it's in not in the greatest format, but it does put out a lot of data. So e-courts, I mean, any case in the country, you can go to e-courts and find out what stage it's at, what the next hearing is, what the orders are. But unfortunately, e-courts does not give aggregate data. So if you're looking for a particular case, you can get that on e-courts, but you do not get any aggregate statistics. And that is what prompted Daksh to create a database where we pull data from e-courts and we analyze that. I mean, we present it in an aggregate fashion. So if you go to our website, you go to our database, you can, for example, if you want to see how many civil cases are pending in Bangalore City Civil Court, you can do that on our website, whereas e-courts does not allow you to do that. More recently, the National Judicial Data Grid gives some kind of summary statistics, but it's not ideal. So, I mean, having said that, so the amount of data that the e-courts is giving out has kind of stayed static. But to analyze judicial problems, for example, Rukmini talked about pendency. Everybody talks about pendency. Now, we know that cases are pending for several years in India. I think by now it's like 4 crore cases are pending across our courts. But what does that actually mean? You know, behind these statistics, there are complex problems. There are human stories that are behind these statistics. And to get to those stories and those problems, the data that's put out is not quite enough. So, for example, the data that's put out will tell us at what stage cases are pending, for how long they're pending. But there is further granularity that's needed. For example, we did a time and motion study in some courts, certain trial courts, and we found that 40 to 50% of a judge's time is being spent on non-substantive hearings, adjournments, notices, summons, those kind of that kind of work that is actually not real judicial work. And judicial time is a precious resource. It's similar to a surgeon's time, in a hospital context. I don't know how many of you have heard interviews by the founder of Arvind Eye Care, where he says, the surgeon has to enter the room and the patient has to be prepared. He just puts on his gloves and he operates. A court should function like that too. The judicial time is a precious resource. It should not be wasted on non-substantive hearings, adjournments, notice, summons, this kind of work. But this kind of data is not available on e-courts. You still need to sit in a court and record, to get this kind of data. So we really need to be looking at more granular data being put out on e-courts. And e-courts becoming a little more, user-friendly. It's a difficult site to navigate. There's captcha at every stage. So we really need to move a little beyond the current structure of e-courts to really do granular analysis. And, Rukmini was saying maybe that now you would not have to go through judgments the way you did for your, no, we still have to. My colleague Shruti and I had done some work on foreigners tribunals in Assam. We went to hundreds of judgments manually. So, the judgments are still not machine readable. They're not in any kind of structure, like uniform structure. So you still really need to go through them manually to get those kind of nuances.
Thanks for that, Leah. And since camera is that said, I think we'll bring Samriddhi and Apurv of CDF to talk a bit about what is the next stage of this, right? How do we sort of use the data that we have to kind of do the work to understand our courts, what's happening with them, what is the potential here? Because I suppose, of course, Sushant is the tech person among us here, but Rukmini is a journalist, we are lawyers. We just sort of want to understand the potential for the tech to do this.
I think since Bharti ma'am is also here, the recent report that CDL and Hub together worked on was the Boxer report. And the struggle that we faced with even taking understanding data from e-courts was annotation, standardization, lack of standardization. So, even when we talk about analyzing data, and even with the help of tech, we are able to say scrape data or gather data. The next level of difficulty comes in maybe like breaking down those data. For example, one instance, say even simple things like IPC was either written in I.P.C, IPC, I.PC, Indian Penal Code, so many permutations and combination, and breaking those and being able to move ahead of that was one struggle. But yeah, with that report, I think we were able to cover at least 3 states, and yeah, it was a lot of to and fro. And so is the case. So was the struggle with, I think, working on Section 66A of IT Act, and that was a similar struggle that we faced. But yeah, on adding to it, Apurv you would like to add something?
Yeah, first of all, thanks to Rukmini for, I think, writing and compiling everything in this book, especially for people like me who don't know. So and I'm talking for myself, I always look at so I've been looking at this NCRB thing, but for me, that was it, the final number of what it is. And that is how in my head, I kind of came up with any argument. But working with Bharti ma'am and others on this POXO report, I really got to see the qualitative side of things and why these numbers are important, especially your point on, the case or a percentage of cases where actually they are turning into a conviction and not an acquittal. And that is happening, but so just tying this, qualitative side to the quantitative side is, especially for me, that is the next step. And also talking about, I think there are ways in which some of these challenges, what I think Samriddhi spoke about, that will get solved. If not now, maybe in a couple of years, with, the e-courts also came out with a recent, like how the next phase will look like. So there will be APIs, there will be more standardization, and I'm sure these problems will be solved. But what we also need to think about is in terms of, even let's say you have APIs in place, one of the problems that Rukmini mentioned in the first chapter was about NCRB collecting only the primary offense. Now, even if you have APIs, even if you standardize the data, you are still missing out on a lot of things. And there are ways in which, so I think in 2015, United Nations Office on Drugs and Crime, they came up with this ICCS, they called, which is the International Classification of Crime for Statistical Purposes. It's a data standard, and it is to kind of standardize that, and they recognize that every country has a different format and different way of collecting the crime related data. So is there a way we can kind of, so there are challenges India need to solve, but can we learn from other countries and come up with a common data standard, so that even if we can compare statistics not just within the states but within countries as well. No, that is not that is not something we would like to solve for now, but at least what is helping us do that. So what a data standard helps is to kind of separate the presentation side of things with the, what you're storing at the back end. So one of the problems that I think in the book, at least the NCRB folks who quote, is it will overinflate the figures if we capture, all the offenses, which is actually, I don't think that's even a point, because there are ways you can work on storing that data in a form, and then even if there are 5 acts or sections for a case, there are ways you can solve for that. So not storing that information and quoting this, I don't see there's a relation between these 2 points, and there are ways to solve for it with these data standards. So even with Akoma and TOSA, and I'm sure Vidhi also worked on it for a bit, even Sushant has tried a few things on Akoma and TOSA, and there are ways, if we are, even if you see, if the judgments are stored in that format, then even if Rukmini had to go through 600 judgments and the time it took, we can actually reduce that to 1/10 of the time that it to fetch insights from the judgment. Now in the Huck report, that there was one indicator where we worked on reading the judgment, which was the sentencing part, because that data was not readily available on the e-courts, and it took us a lot of time. But yeah, through these data standards, I think we can solve a lot of these problems. But then a conversation needs to happen between the people who are developing these systems and the, which is quite rare and which is very difficult to be a part of. But yeah, there are ways to solve it. But these data standardization issues, I'm sure, will be solved in a couple of years, and then we are at a better place, from where we were, let's say 2-3 years back. Over to you, Alok. Yeah.
One issue. Yeah, so I mean, just tying together what people have been saying, one big issue with e-courts is data, the quality of data entry, because the data is entered by these data entry operators at the trial court level. And, the quality of that data entry is quite questionable. Like often orders are not uploaded, we had done a report on land acquisition in Karnataka and Maharashtra, and we wanted to analyze the orders and judgments of the trial courts in land acquisition cases, and we couldn't, because in most of the cases, the judgments had not been uploaded. So, those issues persist. And, that issue, if it's not fixed at that data entry stage, then there is really nothing much you can do. You can't fix that when you analyze. That is a big issue with it.
Thank you.
Can I jump in? Sorry, just also wanted to add it's actually sort of a question both to Apurv and to Sushant, which is that, so on one side, this conversation with the judiciary needs to happen about things like codes and classifications, data entry, APIs, all of that. But in the past, when I have had these sort of conversations, there is also a sense that private providers have moved far further than what we have publicly available. Because when I speak to lawyers, for example, I'm quite amazed at the level of alerts that they get, which is not something that we commonly know. We don't know what cases, but so there is, I feel like potentially also this conversation that needs to happen about how far private providers have got with machine learning, and then to think of whether there's some model with a grant or something that can move towards getting, just so that we're not duplicating work that the private sector is doing on a paid basis. But if that tech already exists and we've cracked some of these things, then just for a public interest purpose, we don't need to reinvent the wheel. So I think Sushant would know more about this, because it is my sense that there's a lot of companies in this space because lawyers want so much, personalized information.
So, I mean, a lot of alerts go out even from Indian Cartoon for people who register their queries.
Yeah.
But that is still right now word and phrases based. I mean, we are trying to do the machine learning bits to categorize and do some kind of provide better filters to people. Because your search still hits maybe 2 lakh judgments. You still need better categorization and better filters to actually narrow down on what you're looking at. So, but as far as I know, no one has done on the whole space. Maybe someone has taken small spaces on arbitration and things like that and built vertical categorizers, but not on the whole thing, as far as I know.
Apurv, did you want to add anything to that?
I agree with Sushant, as in because these are, these are not public initiatives right now. So we don't know as a community, as in small spaces, we know that, someone is trying to do that. Or I think an initiative by the judiciary, especially on the Supreme Court, has been they are converting these English judgments to vernacular languages. And, that is happening. And I'm sure there is some level of technology as an MLA involved there. But I agree in terms of, so one thing that has, at least from our like Civic Data Labs experience, what has helped to convince the state in terms of deploying or at least start thinking in that direction is if we are able to showcase the importance of, if their effort is reduced in any form, in any way, and if we are able to showcase that these are the use cases, this is the open source technology you can use or whatever, that really helps. But that space in itself, it's hard to find that space. But yeah, so that is what I wanted to add. Alok, yeah.
Okay. Thanks, Sushant. Thanks, Apurv. We'll have 10 more minutes of this discussion and then we'll sort of throw it open to questions. So those of you who are here, if you have any questions for what has been discussed, and those of you who are joining us online, if you could put your questions in the Q&A box that you will see on your interface, my colleague Maitri will read out the questions, and if you can direct it to a specific speaker, it'll be much easier for the Q&A to take place. But continuing on this thread of discussion about court data, I think what we've done in about a year, 2.5 to 3 years ago at Vidhi is, instead of waiting for the courts to put out data, what we've started to do is, can we go out there and create our own data sets on this? And this we sort of did by using surveys. And I'll let my colleague Reshma speak about it, because I think we've got 2 very interesting and fascinating data sets on the state of lawyers in this country and the state of physical infrastructure for courts in this country. So I'll hand it over to Reshma to talk about this.
Thanks, Alok. On the...
Just a second. Yeah. Sorry about that.
Yeah. So on the first aspect itself, why we decided to go out and get the data ourselves, it's something similar to what Leah was saying, right? That now judiciary has started making data available. Courts puts district court data case wise, and NJDG, the National Judicial Data Grid, does the aggregate of it. But one thing we see is, one, they're not machine readable. We also see that the numbers, in fact, like NJDG does an aggregation and we don't know how this aggregation happens. So what they combine as, like, say, warrants and summons, what comes under that, which is comparable to an e-courts data, that is really not available. And something that we've noticed, which is that, so in one of our engaged projects where we were asked to work on the pendency, that being one of, like you said, one of the things that everyone wants to like talk about. What we were told that there were 8,000 or 8,800 odd pending cases, but from when we went into those individual high court websites and saw the status, what we saw that 5,500 of these cases were disposed. So what the regulator initially thought was like there are 8 cases pending, was actually 2,333 cases that were pending. So that's another question, what Leah also raised, another issue, that these are officers who are sitting and filling in the data. So it entirely depends upon the will of the judge who is chairing the computer committee, the registrar IT who is in charge of it, and also like the members who are actually entering the data to make sure it's updated and it's also available in a format that's accessible. And yeah, so like to the specific question that Alok mentioned, where there were two surveys that we had conducted. One was a survey of the advocates where we surveyed around 3,500 advocates across 8 high courts. And something that we found very interesting is that I mean, we see the profession as again senior advocates or advocates. So there are the advocates who are very famous and who are known, and advocates who are like lesser known. Something very interesting that did come out from a survey is that so we piloted the survey in Delhi, and for which there was one question on what's your average income, and this was for advocates who have with 2 years or lesser practice. And the bracket that we put was 5,000 to 20,000 rupees, and we saw that 80% of our responses fit into that bracket. And what the advocates told us was that your base is too high. So for the remaining 7 high courts that we did the survey, we changed it to 2,000 to 5,000. And what was very interesting is that in Allahabad, Bombay, Kerala, and Patna, which was like 4 out of the remaining 7 high courts where we spoke to advocates, 45% of the population that we spoke to, they fall under this category. So per month. So that's their monthly income, and that falls under, this is the bracket they fall under. So, and what courts fail to realize, or I mean, maybe they do realize it, failing to acknowledge is that these are factors that contribute to efficiency. These are factors that contribute to how your case is speeding up. And another very important thing that really contributes to is infrastructure. So, I mean, these courts are ultimately service delivery centers, right? And they are workplaces for some. They are places that some places people are coming to get their justice, which ultimately translates to getting their amount back. It's justice is like a very heavy word, but ultimately it translates to getting their land back or getting, the money back. Or in criminal cases, it's just the idea of seeing someone behind the bars for a crime they've committed. But so that place needs to be conducive to be able to function in this manner. So we'd also done, so in 2018, we'd done a survey of 665 district courts. And we also spoke to 10 litigants in each of these courts. And some really, I mean, it's something which we all knew would be the case, but some really appalling statistics did come out of the survey. And one that gets quoted very widely and that the report got reported on across is, I mean, it's a survey about courts, but incidentally toilets was something that was really caught on and that got captured. And one thing which we need to give to the current Chief Justice of India is that, so most of judicial reforms, that I think that's how it works. It depends whether you have a champion judge for it. And most of them take the causes which they feel are the same. And incidentally, Justice Ramana has taken up the cause of infrastructure, and he's actually done, I mean, the Office of the Chief Justice is actually doing a survey of 6,000 trial courts, and that's an ongoing survey. And Print has actually released the preliminary findings, and we see that from our report and his current survey, the study is very similar. And there's nothing has changed in the last 2.5 years. And some of the data we see is that, so out of all the courts that we surveyed, there were only 40% court complexes where they had functional washrooms. And when we say functional, we're saying basic. It's cleaned and has running water. That's all that we're talking about. So 60% of the courts don't have it. 100 court complexes did not have washrooms for women. And in fact, the CJI's survey puts that number at 22% that do not have any facilities for women and 16% who do not have toilets at all. So, and these are places where there's court staff, there are advocates, and there are judges who sit like on a 6 to 8 hour basis every day, and then they function. So, and these kind of data points regarding the annual income or the monthly income of advocates, the infrastructural facilities that are available, or actually most of which that are not available, they really contribute to the functioning of a court itself. So when you look at a narrative of 4.06 crores pending, out of which like 95% are in the district and subordinate judiciary, the district and subordinate is the least, it's the most overlooked of all the courts. That's where the infra numbers look like this. That's where the advocates earn like this. So it's an add up. It's just the effect of all of these finally adding up to those numbers. So yeah.
Thanks, Reshma. And I think what sort of comes through from the discussion, and thank you all, those of you who have contributed to this discussion with your thoughts, with your work. I think we've gotten a fairly wide picture of the work that has gone into it, what it tells us about the state of our institutions, and what lies ahead of us. Because, as I said, this is still day one. And I think one recurring point that has come through, starting all the way, I think when we started off the discussion, even to what I think Reshma just mentioned, is who puts that data in. And it's somewhat unfortunate, but every 2 years I find a reason to use this quote. It actually comes from apparently a judge who had served in India during British times, and it is reported by the ICS officer, the then IAS officers, who sort of approached this judge about running a district in India and all of that. A young enthusiastic person goes up to him and says, "What do you know about this? What do you know about that?" The judge, old wizened chap, says, "Listen, young man, the government of India is very fond of statistics. They create nice graphs, they raise it to the nth power, and they say all sorts of things about it. But you must remember that at the end of the day, the numbers are put in by the local chowkidar, and he puts in whatever damn well he pleases." So to me, it's well, mildly depressing, but also mildly hopeful. That one, we find that it's a recurring problem. It's not something which can be fixed easily, and there is no perhaps one simple fix, but it also feels like a manageable problem. It isn't so insurmountable, so defeating in that way. But taking up from our research and what people have spoken about, maybe Rukmini, the way for us to sort of kind of round out this discussion before we throw it open for questions and further comments is of all the data points that you have heard in your own research and your own work into this. I'll pin it down to 3 questions, right? Which part of your research confirmed or put a number to something that you knew, something that you thought makes sense, but now you have a number for it? Which part of your research and also what you have heard told you something that you hadn't thought of at all? Like it was so completely out of the vision that this number has suddenly thrown up. And a number or a data point which sort of told you that something that you thought you knew was completely wrong, right? And I sort of want to use this sort of 3-step question just as a way of putting to our audience and to the people here about the potential that using data has to talk about courts and law and so on. And if you could take like a couple of minutes, just specifically, how do you think that you would say this, answer these questions?
Yeah, thanks so much. And yeah, so many of the issues that came up in the book, or the sort of thinking and conversation around it, have come up today and echoes of it. Plus, I really, not as a concluding remark sort of thing, but I really do see a way forward. Yeah. I agree with Apu that things might change in a couple of years, and I agree that these aren't insurmountable challenges either. There are some, we can't go past the underlying stuff because then that will just get replicated, those issues. The thing that confirmed what I felt that I was already seeing was the issue of parental criminalization of consensual couples. I thought I was seeing it all around me. People were telling me these stories. When you go reporting, people love to. I love to talk to people, and they like to talk as well. And people love to share their love stories. You feel that you don't. And I have a sort of inter-regional. No, people always ask me, "Ma'am, do you have a love marriage?" Because it's so rare in India. Yes. And then if you have, then that's it. That's like open season to talk about all of their thwarted relationships. So you do know that this is happening, that interreligious marriages in particular are being thwarted left, right, and center across the country. And I felt that I wasn't perhaps expecting to see it in sexual assault statistics, but that is the story that in a way ended up coming out of it. So yeah, that's something that was confirmed. Something that surprised me, which maybe it's because I hadn't worked on this, but the principal offense rule in the NCRP really did surprise me. And as Apu says, it's dispiriting that the explanation for it is that it will artificially inflate numbers. Cross tabs exist. All of us work with cross tabs, so it's not insurmountable. And I have to give the NCRP credit. Many countries do operate in this same classification, so it's not something esoteric that India has chosen. But it was never in the disclaimer. It was never there in the fine print, and that's the appalling part of it. Similarly, to speak of fine print, at one point, I think in 2012 or so, the NCRB moved from calculating crimes against women on a denominator of the entire population to a denominator of women alone, and it was there in like 6-point size at the bottom of some table. So you can just imagine what the graphs look like in the years after that, and all of the specious theorizing that happened around it. So yeah, always look at the fine print. But your lawyer will tell you that anyway. And something that I thought I knew that was wrong, I'd say migration I found very surprising. The popular narrative around migration is that there is so much of it, and that it is that rural to urban migration is really the driving force of how our cities are changing. Let me be clear that there is a lot of migration that isn't captured in the data. It's seasonal. I talk about it. Some of it is distress, some of it is returning. Our classification categories are far too narrow to capture the the lived experience of migration in the country. But permanent sort of moving from one place to another, particularly rural to urban, I would have put the number at like 20% or something. So, the fact that if you live outside the place where you were born, you are a huge outlier in this country was very surprising to me.
That's very interesting. And again, for those of you who haven't yet read Rukmini's book, please do so. And I think this chapter on migration was, at least for me as well, very illuminating, very eye-opening. And I, of course, read along with Chinmay Tumbe's book on migration. So it sort of gave me a lot more perspective and a lot more full picture on that. So with that, we have about 15 minutes before we close. I suppose let's start with our audience who's here in person at Rework. It's fine. I think I'll spare you that effort now. So if you have any questions for any of us or any of the panelists whom you heard, and likewise, those of you who are hearing us online, if you could put your questions in the Q&A box. I think Maitrey, if you could start going through it, and I'll just call upon you, can read them. But any of you who are here, sorry, Shashank, please.
I mean, I just glanced with the book TOC, and I mean, it's impressive how many the things you have covered in that one book. I'm just impressed. Surely read it.
Yeah. As I was just telling Rukmini before we started, we could have had, there are about 12 chapters, I think, 10 chapters. We could have had 10 separate events for each of the chapters. And each of them would have been as long, would have been called as long.
Yes, exactly.
So let me also say that I share the same. So any of you who want to ask any questions on this or any comments?
Yeah, I had a slight concern about the machine learning. I mean, I've worked on a little bit of that. I think obviously.
Why don't you come up a little bit?
Obviously, machine learning kind of addresses almost all the facts that you mentioned about data quality and this IPC being written in 100 million ways that you never thought could be written. But I think conditional. There is this whole ideology that comes with it, almost like a Californian ideology about how we are like one app away from world peace or something. So I think that's kind of concerning because a lot of the machine learning kind of analysis doesn't come with an interpretable base. So do you have concerns generally that if Supreme Court is, let's say, coming in with all of these things which they're intending to see? For instance, I'm interested in, is there consistency in the application of law? So for instance, I mean, maybe not a good idea in this time, but like, do judges, for instance, appeal to the Ramayana or something to instead of the Constitution? Now, these kind of things can be studied, but I think anything that you study and say about comes with so many more finer caveats that you can't explain to the lay public about the models and things. So do you have any concerns?
That's a great point, and something we should all be thinking about as we go forward. I'm not a machine learning zealot, but I do think that there are questions that can be answered quantitatively, and that we are, we're failing people in giving a picture of how the judiciary operates by not being able to answer these simple quantitative questions. We're not able to answer simple questions about what the most common sorts of cases are, what is even the fact that the NCRB, for example, it's only giving its own section, sort of selection of IPC sections. So we don't know about the rest of the universe of it. Just as Leah pointed out that they have not, been able to remove the manual component. I can't imagine trying to answer any sort of broad social question about it purely through machine learning. But there are, I'd say that in fact, there is data reporting that needs to go into the machine learning process. So one very striking news story that has stayed with me that was done by ProPublica, I think in the US, was around bail setting algorithms and how these algorithms, and it sounds Luddite to say it, but the algorithms were racist because the people making them were racist, and the algorithms were less likely to give bail to African Americans because that is, despite extremely similar preconditions. So, none of our journeys will stop at machine learning. They'll have to go into investigating that part of it as well. But there is a certain base that can, even just to the fact, to simple things like not requiring a text search for 376, for example, or not missing just the IPCI.P.C sort of example of things. I would imagine it can curate a sort of buffet of things for us to then work on from there. But yeah, I cannot possibly see myself feeling confident about putting out a piece that was based purely on machine learning, just because of all of this, because of the way we know how things operate. At least I'd feel obliged to, dip into a sampling of cases to see what was coming up, because we'd end up telling dangerous stories. If we were using machine learning to tell stories about, that a section on causing hurt, the story we would be telling is that a large number of Muslims are being charged with causing hurt using a poison or with drug peddling. It's again, we'd have a racist algorithm in that respect. So yeah, there's no way that anyone who produces work based on that alone will need to do our own reporting into what they produce. I agree.
I think Ms. Bharti Ali has a question. She has raised her hand. Bharti, would you mind? Yes.
Yes, thank you. So I'm very curious to actually figure out your experience with getting data on cases of sexual assault, because a lot of it is protected in the name of privacy and confidentiality of the victims. So how do you really access, and how do even victims access, data on their own cases? They have to constantly depend on lawyers, pay out of their pockets huge amounts of money, whether they can afford or not. So how do we change that situation? What was your experience on that? I'd like to hear a little more.
I don't know if further restrictions have been placed after I looked at it in 2014 and 15, because at that time, in fact, there was a problem with not enough privacy being respected. Everyone's name and address was there in full. Not everyone, but large numbers of names and addresses were there in full. So perhaps there have been further restrictions since then. And yes, there is a trade-off between personal freedoms and anonymity and the sort of questions we want to answer about this. In terms of further documents that I wanted, often in many cases, these were obtained physically through going to courts and from public prosecutors, with the sort of rapport building, which is exactly what you would do, or all of those sort of non-technical ways of getting this work. I shouldn't hazard any theories about how victims can get more access to this information, because that's really not something I know about. So happy to hear someone else.
I'll just offer one thought, and this is something that I would like our courts to think about this, because it's not an easy solution, and what Rukmini has said hints at the complexities of it. Because courts have taken the effort to make child-friendly courtrooms or procedures which encourage women to come and report it. The way to, I think, close the loop, and it's a very important question that you've raised, I think, is for our courts to think about these issues, because we have Sushant here who also constantly has to deal with issues of, how do I anonymize this data? Because courts just dump their data, and Sushant's crawlers collect it, suddenly find, oh no, I've collected information I shouldn't have. And it's a constant struggle also there to make sure that, you can anonymize properly. But this is a conversation that, it needs to be had with the courts to say, listen, here's something, you can solve two big problems. One is, of course, you can ensure that victims have adequate knowledge and access of their cases. Here's a way you can reach out to them. But two, you can preemptively address any risks of, de-anonymizing someone's identity, especially a child victim of sexual abuse or a woman who suffered sexual assault. Here is how you can address it. Unfortunately, that conversation has not happened in courts. And I think that is why we find ourselves in this muddle where we're trying to solve three different problems in our own ways and not getting anywhere on that front. But thank you for that.
I'm just going to add one thing, which is of the point of also bringing the media into this conversation. The fact that full FIRs and charge sheets in sexual assault cases are freely made available to the media, and very often on very biased terms when the police want or do not want something to get out. I remember about 5 years or so, maybe more ago, of a complaint of sexual assault in a major university in Mumbai, and the entire charge sheet was essentially reproduced on the front page of a tabloid then. And her fellow students were campaigning outside the newspaper's office, but it was in absolute voyeuristic detail. There was no other justification for why that much detail was available. And recently I was reading about the trial of a police officer who was convicted of the sexual assault and murder of a young woman in London. And when I was looking at the news reports around it, that's the point at which I realized that it was only at his conviction that the media realized that she was sexually assaulted prior to death. In India, we would have all been told that on day one, whether he was convicted or not, in absolute detail with no respect of the victim's protection. So I really think that we need to bring the media into this conversation as well. And it seems like a terrible time to argue for restrictions on the media. But when it comes to crime reporting, I am horrified at what we allow to pass in the name of news reporting.
Yeah, thanks for that, Rukmini. Maitreyi, if you won't mind, could you unmute yourself? And I see we have about 10 questions or so. If you could pick 3, we'll try to answer those, and then if we have time, we'll move on to the rest. So Maitreyi, if you could also let us, if it's been directed to anyone in particular, so if you could just let us know the questions.
Absolutely, Alok. So the first question is by Advait Nasal. Forgive me if I'm mispronouncing your name. This is directed at Rukmini. Would the fact that the constabulary barely has any work incentives, like lack of promotions or low salaries, be the cause for lack of reporting?
Could you just read out the 3 questions and we'll answer them if possible?
Sure. So the next 2 questions are asked by Basil Ajit. Just like how, and these are directed at Sushant, just like how the union government opening up data APIs for public to use, is there any movement towards the NIC opening up APIs for e-courts and other court websites for the public to use? And the third question also towards Sushant is, since there are issues with data entries in courts, each court/tribunal adopts different softwares or tools for its operations. Would it be too hard for a uniform adoption of software with data validation while doing data entry solve many of the issues?
We'll start with Rukmini and then I'll hand over to Sushant.
No, great question, and something that I spend a lot of time thinking about, not just for the police, but sort of across the board, which is it fair to have this conversation together about difficult work conditions, even for district court staff, and poor incentives, and sort of abhorrent and morally repugnant behavior. And I'm not sure that I'm in favor of these being a joint conversation, because both of these are things to be corrected on their own, and by making one dependent on the other, we're sort of placing morality in a dependent kind of situation, which I find problematic. So of course the police are underfunded and work in horrific circumstances, and suffer terrible health conditions, mental health, all of that. The salaries are terrible, we see all of that, but I find it difficult to have this conversation in conjunction with police behavior. And so in a sense we're sort of asking the question of, if they were paid better, would they take less bribes? And I find it difficult to have that conversation together. I am in favor of those 2 being separate conversations for everyone, from a traffic policeman to an MP. These have to be separate conversations.
I'll just hand it over to Sushant. I think there's a question on NIC APIs and also on.
I mean, I'm actually a sufferer of the NIC, whatever does. So I don't know how they actually works. But yes, I mean, what you're saying is will be good actually if the courts have a standard way of uploading data, standard way of anonymization, because I mean, there are problems of anonymization and also of not reporting. I mean, there are cases where I've seen just someone will write a letter to the High Court, and High Court will delete the order from the website, their own website. So which means only Indian Kanun has the actual order. So which isn't really great news, in fact. And so there are problems in that one. It would be great if there is a standardization across, but also to point out, actually all the high courts are, I think, administratively independent. They have their own case management system. They have their own how the things are actually allocated. So to think about complete uniformity is also probably not an easy task. And from what I've heard, Nick does give some standardized software which doesn't suit some of the high courts. And they want to actually go and hire private Infosys and TCS to do the job. And I don't know how good that works.
And just to add that we got to see this sort of heterogeneity when the pandemic hit, right? Every single court jurisdiction in the country used whatever Teams or Cisco WebEx that they wanted. And the fact that even after 1.5 to 2 years, we don't have one standardized Zoom or whatever is really shocking.
It is, and at least I've heard this also from practicing lawyers. The experience can vary so dramatically and so differently. We have time for 2 last questions and we'll then close. So Maitri, if you could just pick 2 questions.
Yeah. So this is a question for Rukmini from Kaushiki Sanyal. Why do police register cases under certain sections and not others? Is it because they think it will be easier to get conviction or threshold of proof required is low? Is there any story hidden in this?
And one more question.
And one last question is, I'm sorry to those whose questions are getting left out. How may the National Judicial Data Grid and the NCRB statistics be better calibrated in terms of data collection or categorization to capture the granularity of crime in India?
Okay.
Okay. So yes, there are a number of reasons for why the police choose some sections or the other, ranging from lack of knowledge of the law, right upwards to more nefarious reasons. And yes, choosing sections that they feel will are more likely to lead to convictions is true. Choosing sections that in which they feel they can make instant arrests and which bails are less likely also happens, whether it is sometimes with the purpose of actually keeping someone who they feel has done something wrong behind bars, or it is settling scores, or it is for money. All of that happens. So this too is a question that it would be great to be able to answer this with simple quantitative data for similar sets of circumstances. What are the sections that are applied, whether it's different in different parts of the country? So it's a good question to which there isn't one specific answer. On granularity, I'm going to quickly answer and then pass it to Leah, which is that for the NCRB, they should be doing, I believe that they should be making data on all sections available. They don't need to publish, the answer I was given is already our PDF is 100 pages. And don't put it all in a PDF, right? You can put it in Excel and GitHub, and only the people who are interested in it will download that. You can give summary statistics, that's allowed. So I would say cross tabs with all of the IPC sections, and for all crimes, I'm sure it's a lot of work, but the NCRB is its own body. This is their job. On the National Judicial Data Grid, I'll pass it.
So NJDG pulls data from e-codes. So if we want more granular data on NJDG, that has to be done at the e-codes level itself. So if you want to go beyond whatever is captured in e-codes, the kind of hearing data and the case data, supposing we want to know actually how much time a judge is spending on a hearing, or how many adjournments were taken, which lawyer asked for the adjournment, things like that, that will have to be captured by e-codes, and only then it will reflect in NJDG.
All right, thank you. I think that's all the time that we have for today. Thank you all for joining us. A small list of people to thank. First of all, thanks to Namrata, who has so patiently addressed this particular infrastructural issue for us. She's behind the camera, so you can't see her, but she's been helping with all of this. Thanks also to my colleague Deepa, who's helped set up everything. Maitreyi, who is joining us from Zoom, and who put this together so that this is our first hybrid event. We've had people in person and people join online. So there may have been some glitches. So all of that I will say I'm sorry for, but I hope this has been a good experience. Thank you to our ISL interpreters Atul and Udya for having been with us all through the course of this discussion. Thank you to all those who joined us online. I can see Apurv, Ms. Bharti Ali, Devyani, thank you for being part of this discussion. I think you brought very valuable insights, and I hope we can stay in touch. As I said, this is an ongoing conversation. Likewise, those of you who joined us in person, Samriddhi, Leah, Sushant, and of course my colleagues Reshma and Apurva, who filled in somewhat at the last minute because of circumstances on to talk about our work. And finally, thank you, Rukmini. I think this was a great discussion. It was a little bit last minute that we planned, but I think we've had a great discussion all the same. And again, I would urge everyone, please do pick up her book. It is a fantastic work. I'll repeat, and my colleague Maitri is going to put up the email address once again for your reference. If you would like to purchase a copy of this book, please send an email to the email address that you see on your screens along with your address, and you will be able to get 40% discount on the book as well. Thank you all once again, those of you who joined us in person and online. I hope this was a useful discussion. I hope you've taken a lot away from this. We will be uploading this shortly on YouTube. Thank you and good night.